Hi, my name is Larry Newman. I'm an upstate New York attorney. Our practice concentrates on defense of DWI cases. Today I want to talk to you about creative plea bargaining when it comes to reducing a DWI to a DWAI. Now, depending upon the court you're in other words, depending upon who the judge is and depending upon who the prosecutor is for that court, remember the little town and village courts have an assigned assistant district attorney. Depending upon who those people are, will be able to say whether they would even agree to a creative plea bargain on a DWI case. You know, these are people, and people sometimes have policies, and people sometimes have biases, and they come into the court with beliefs. Some judges, just like some prosecutors, believe that there should be a certain minimum standard of punishment for DWI cases. Other prosecutors and other judges are more open. It's very subjective. That's why it's important to know the court, know the judge, know the prosecutor in terms of what their history is and what their beliefs are and what their biases are, because sometimes we're able to negotiate a creative plea bargain. Remember, we're going to have consent of the judge to whatever plea bargain that we make with the prosecutor. So, three things that we've been able to sometimes do with a DWI case, and it depends upon the facts of the case, depends upon the complete situation, whether it's an accident, no accident, BAC, blood test, whatever it was, and how they acted with the police. There's a lot of little factors, but overall, these are three potential creative plea bargains to reduce a DWI down to a DWAI charge. Sometimes a judge would be amenable to tacking on a little bit of jail. When I mean county jail, local jail. Sometimes it's just a weekend in jail, 2 weekends in jail, could be 3-4 days in jail. But some prosecutors and judges will agree to reducing a DWI to a DWAI, which they normally don't reduce based on the facts and circumstances because of adding a little bit of jail as a punishment. So that's number one, jail. Number two, sometimes if we have a DWI case and they don't want to reduce it to a DWAI, we could say, listen, the person will agree, our client will agree to place an ignition interlock upon their car for 1 year. Normally with the reduction to a DWAI, we don't have the requirement for ignition interlock device upon the car. That shows them that you're going to be alcohol-free when driving for 1 year and prove it. Now, the recourse that the judge and the prosecutor have on cases like that is the condition being the ignition interlock device. If you violate the ignition interlock device, they can bring you back to court and resentence you to jail on that reduced charge of a DWI up to 15 days in jail. The third way, sometimes we're able to reduce a DWI to a DWAI, is to say the person is going to agree to go into and complete an alcohol/drug treatment program. So that could be a condition placed upon the conditional discharge. The person is going to complete a drug alcohol program and provide proof to the prosecutor, proof to the court, and that will be a main condition of their conditional discharge. These things, jail, ignition interlock devices, treatment programs, are not usual things that go along with a straight reduction to a DWAI. That's what makes it creative, because what we're doing is we're giving them something to get something that we might not normally get. Remember, everybody needs reasons, the why, that they should do something. So we need to balance out the scales, so to speak, and give them something so that we can get something. If you have questions about your DWI case in the upstate region of New York, we handle the Finger Lakes region, give us a call, shoot us an email, fill out the form on our website. Be more than happy to discuss it with you. And thanks for watching this video.